Hello. Hello. Check. Hello.
Very good morning to all the dignitaries of the dais. I'm very sorry for the late. Dignitaries have arrived. Shortly we are going to commence our program. So we call this state consultation meet from all the stakeholders. That is the honorable judges dealing with the POCSO cases, Juvenile Justice Board Principal Magistrates, and PPs who are attending the POCSO courts, and SJPU police personnel, and DCPOs, in charges of Sakhi Center, and also Bharosa Center, and the chairperson and members of the SEPCR. We thought that these officers are very relevant as they are dealing with the POCSO offences. So with this, for this 2 days consultation meet, I hope that you will enrich or further add to your knowledge to dispense justice to the victims. Thank you for your patient sitting. Thank you for your kind cooperation. For my officers, I wanted to convey the message. Now the Honorable Supreme Court of India, the Honorable the Chief Justice of India, and the executive dignitaries arriving. Rakesh. Kindly be seated. And namaskar and a very good morning to one and all present over here in the state level stakeholders consultation meet 2025. Before we begin with today's consultation meet, let us take a moment to acknowledge one of the most urgent responsibilities we share as individuals, as professions, and as a society. Every child has the right to grow up in a safety, dignity, and without fear. Sexual abuse is a profound violation of that right with lasting consequences that affect not just the individual but the fabric of our communities. It is our duty to ensure that survivors are heard, believed, and supported, and that system of prevention, justice, and care are strengthened and enforced. It is with that spirit this state level stakeholders consultation meet is being held today under the aegis of Women Safety Wing, Women Development Child Welfare Department, UNICEF, and Telangana State Legal Service Authority in this auditorium. Dr. MCRHRD, Human Resource Development, Hyderabad, in the august presence of my Lord Honorable Sri Justice Suryakant, Judge, Supreme Court of India, and Executive Chairman, NALSA, and the Honorable Chief Minister of Telangana, Honorable Sri Revant Reddy Garu, and my Lords, Honorable Sri Justice Sujaypal Garu, Acting Chief Justice for the State of Telangana and Patron-in-Chief of Telangana State Legal Service Authority, and Honorable Sri Justice P. Samkoshi Garu, Judge, High Court for the State of Telangana and Executive Chairman of SALSA, and other honorable judges of the High Court and other dignitaries, a very good morning. I, Panchakshri, Member Secretary, Telangana State Legal Service Authority. On behalf of all the 4 departments, I welcome you to this consultation meet. The dignitaries of the dais, participants present over here who have graced the occasion, ladies and gentlemen, to the city of pearls and a historic and culturally rich metropolis, Hyderabad. We are deeply honored to have among us a galaxy of distinguished dignitaries whose presence today elevates the significance of this occasion. May I now invite our today's chief guest, Honorable Sri Justice Suryakant Garu, Judge, Supreme Court of India and Executive Chairman, National Legal Service Authority, to kindly grace the dais. I request Sri D. Kiran Kumar Garu, Secretary DLSA, to escort the Honorable Suryakant Garu. Now I humbly invite today's our guest of honor, Honorable Sri A. Revant Reddy Garu, Chief Minister of Telangana State, to kindly adorn the dais, and I request M.A. Javed Pasha Garu to kindly conduct our esteemed guest. Now I humbly invite today's our guest of honor, Honorable Sri Justice Sujay Pal Garu, Acting Chief Justice, High Court for the State of Telangana and Patron-in-Chief, to kindly adorn the dais, and I request Vikram Garu to conduct our esteemed guest to the dais. Now I humbly request respected Dr. Jitendra, IPS, Director General of Police, Telangana, to kindly join us on the dais. Now I request respected Madam Cynthia McCaffrey, representative of UNICEF India, to kindly take the seat on the dais, and I request Milind Kamble, Secretary, Legal Service Authority, to escort Madam. To begin with, I humbly seek permission of the Honorable Chair to declare the inaugural session as open. Thank you, my Lord. The inaugural session is declared as opened. As a gesture of our heartfelt respect and in recognition of their distinguished service to the nation, we now present saplings to our honorable guests on the dais. To do the honors, I now request Honorable Sri Justice Sujay Pal Garu, Acting Chief Justice of Telangana High Court and Patron-in-Chief of SLSA, to kindly present a sapling to Honorable Mr. Justice Suryakant, Judge, Supreme Court of India. Sapling. Ivama. May I now request Honorable Justice Maushmi Bhattacharya Madam, Judge, High Court for the State of Telangana, to present a sapling. No, Sorry, Milord. I request Honorable Sri Justice P. Samkoshi Garu, Judge, High Court for the State of Telangana, to present a sapling to Honorable Sri Justice A. Revant Reddy Garu. Sorry, my Lord. Honorable A. Revant Reddy Garu, Chief Minister of Telangana State. May I now request Honorable Madam Justice Maushmi Bhattacharya Madam to present a sapling to Honorable Sri Justice Sujay Pal Garu, Acting Chief Justice, High Court for the State of Telangana. May I now request Ms. Charu Sinha Madam, Additional DGP CID, Women Safety Wing, to present a sapling to Sri Dr. Jitendra IPS, DGP Telangana. Now I request Sri Dr. Jalalam B. Tafassi, Chief Field of Office, to kindly present a sapling to Madam Cynthia McCaffrey, representative of UNICEF India. Now I request all the dignitaries present on and off the dais and the esteemed guests, participants and everyone present in this auditorium to kindly rise for national song Vande Mataram. Thank you, my lords. Thank you. May I now request Madam Cynthia McCaffrey, representative of UNICEF India, to kindly deliver the welcome address. Madam, please.
Honorable Justice Suryakant, Judge Supreme Court of India, Shri Reddy, Honorable Chief Minister, Honorable Justice Paul, Acting Chief Justice of the High Court of Telangana, Dr. CHANDRA, Director General of Telangana Police, all representatives distinguished from the Judiciary Government of Telangana, all stakeholders, namaskar. On behalf of UNICEF India, it is truly our honor to join you today at this landmark event that demonstrates the highest regard with which Telangana holds the protection of children's rights and well-being. And let me begin with this simple quote: "Justice is not served until it reaches the last woman standing in the queue." These are not words from an international convention. These are words written by Savitribai Phule, a charismatic social reformer of India who promoted girls' education and women's rights in the 19th century. And just this month, on July 2nd, the National Institute of Public Cooperation and Child Development was renamed Savitribai Phule National Institute of Women and Children Development, that recognizes the incredible leadership that India has had for women and children's rights. So it's long before any international conventions or international law that Phule gave us the accountability and the responsibility to defend those who are in the most need of their rights in even the hardest times. And India has stood at the helm, recognizing and also creating frameworks that are not just the minimum standard for children's rights, but constantly looking at how to ever expand the effort for children's rights and making sure that you're building a society that is a model across India, but also for the globe, to create a place where children can survive safely, but also to thrive and dream their dreams and reach their aspirations. So that's why it is particularly an honor to be here and to welcome all of us as we sit together with those of you who are creating the legal frameworks, and also those of you on the front lines, the first responders, police, judges, prosecutors, the social workers, counselors, our child line functionaries, civil society, families and communities themselves, who are meeting and trying to respond to difficult cases that help children to survive but also rehabilitate and thrive. Let me emphasize the following points as we think about the next 2 days. Foundation. The Convention on the Rights of the Child is the most ratified convention in the world. It is a marker of global cooperation that we are here to protect children's rights and their well-being. And protecting them from violence, protecting them to be safe, is a bedrock a cornerstone of all their other rights. If a child is safe, then we're able to build on that, their health, their nutrition, their education. And then with that, they can grow resiliently. And so can nations around the world. Second, obligation. When we think about that foundation of rights, it reminds us that a child's rights is not a nice thing to do or a charitable thing. It's our obligation, it's our responsibility. And it's the whole of society that has to do it. It's cross-disciplinary. As we will talk about more and more today, sexual violence is pervasive globally. And it's harmful in many ways and for many reasons, including some deeply entrenched social norms. And so how do we work together to create that social power and change the social dynamics that enable children, and particularly those marginalized children, especially girls, to be able to have those rights? And at the same time, how do we look at the types of barriers that you're looking at every day that helps ensure disclosure and justice for individuals at every level, in every aspect, institutional and societal? I've talked about these prevalence. So what does that mean? As we look at India, some of the figures, if we look at NFHS 5 data from 2019 to 2021, almost 40% of women, 39% of women across India between the ages of 25 and 49 report having had sexual contact before the age of 18. Within that age group, 10% report having had sexual contact before the age of 15. In addition, India, and this state, is not just looking at the present challenges, but we're also looking at upcoming challenges like the internet, which creates opportunities, but it's also creating a global market for child sexual abuse materials and nefarious opportunities. So that is our foundation, obligation, and the third is demonstration, demonstrating that we can make change. And India has demonstrated how to make change through its strong legal and policy frameworks that protect children from sexual offenses online and offline. And it's commendable what India has done as we look at services that provide to survivors special courts, legal aid, support persons, one-stop centers, and other services that help rehabilitate children. And they build on strong foundations that we see in the Ministry of Women and Child Development through Shakti and Vatsalya missions. This demonstrates India's commitment, but also building these strong foundations and meeting its obligations for children. I'm glad to be here because I've had the opportunity to talk directly about Bharosa centers by the Telangana Women's Safety Wing, the SHE teams, the Bal Raksha Bhavans of all child protection services coming under one roof, converged in one place, which is what children need. The efforts made in Hyderabad to issue identity certificates, Aadhaar, caste, disability, to all children wherever they are, care institutions, and all of these initiatives that build child protection across the state. My fourth is steadfast action. It's important to demonstrate what we're doing, but at the same time, how do we continue to expand action and the care journey that's necessary for a child so that they have professional restorative help throughout their journey. December 19th has been declared the Day of Prevention of and Healing from Child Sexual Abuse. It calls for 3 actions, and I put them on the table for our discussions in the days ahead. First is strong legislation that meet global standards, that can be a model and can be steadfast. India, I'm happy to note, and as I've said, has done so. Second is a call for strong child protection systems with adequate resources. And we're seeing that as we look at Mission Vatsalya and Shakti. December 19th also calls for supplementing that from states. And we're seeing that here in this state. How do you make sure you complement from all levels those strong child systems? And 3, December 19th calls for attention to working with communities. And here I would say it's worth our extra attention. We have to be where children live, learn, and play in order to protect them. Because in order to really make a change, we want to change some of the societal norms. And the greatest part of justice is prevention in the first place. So strengthening those investments in working with communities, working at the sub-district level that allows children to be seen when they're at risk, early detection, investing in things like teaching children about safety, creating child-friendly spaces that allows them to speak up about violence they may be experiencing. And all this helps to break silence and the stigma. Closer to communities also means it's easier to talk with adolescents who are often at a crossroads, and being able to talk to adolescents, giving them education that gives them agency, as well as the ability to make informed decisions. Comprehensive reproductive health can help bridge those gaps, and India is making great strides as it's working through the Government of India's School of Health and Wellness program under Ayushman Bharat. These are very important practical interventions that make a difference, and I commend the Women in Safety Wing of the Telangana Police, which is taking these actions in similar strides. My fifth is partnership. UNICEF is very happy to be here, looking and working with partners like all of you. UNICEF works with government at the national level and at the state level in order to engage stakeholders, in order to help build capacity of workforce, those on the front lines, in order to help build systems that rehabilitate survivors and genuinely bring technical support that can help create child-friendly procedures, child-friendly spaces, and engage communities. So with that, I'd like to just reiterate the 5 points that I hope we build on here, and that UNICEF is committed to not just rattling off and saying we do these things, but how do we expand them even further and bring the lessons that the state is proving here across India, but also how does UNICEF take that globally and help protect children around the world. So building the dreams into reality. The foundation, our obligations to meet that, demonstration, steadfast action, and genuine partnership together. And I think Dr. Ambedkar, he summed it up best when he said it is not enough to dream of a better world, one must work tirelessly to make it a reality. So thank you to all of you who work tirelessly to make it a reality.
Thank you, Madam, for the warm welcome address. May I now request Sri Dr. Jitendra IPS, DGP Telangana, to address the participants. Sir, please.
Honorable guests for today's conference for ensuring justice, rehabilitation and reintegration for child victims, strengthening POCSO and child protection ecosystems. Honorable Justice Shri Surya Kanji, Judge Supreme Court of India and Executive Chairman, National Legal Services Authority. Honorable Shri A. Revant Reddy Garu, Chief Minister of Telangana State, Honorable Justice Sujoy Paul, Acting Chief Justice, High Court of State of Telangana and Patron and Chief, Telangana State Legal Services Authority, Cynthia McFerray, Representative of UNICEF in India, all the Honorable Justices of Telangana High Court, members of Judiciary, esteemed dignitaries, police and other government officials, civil rights experts, representatives of civil society and development partners, especially Ms. Charu Sinha, Chief of Women Safety of Telangana Police, and Ms. Anita, Secretary for Women and Child Welfare Department, and all boys and girls, good morning. It is a privilege to be part of national platform that brings together key stakeholders committed to child protection and justice delivery under POCSO Act, Juvenile Justice Care and Protection of Children Act. At the outset, I extend my warm greetings to all the participants and commend the efforts of Judiciary, Women Safety Wing of Telangana, Women and Child Welfare of Government of Telangana in organizing this critical and timely conference. POCSO Act and the Juvenile Justice Care and Protection of Children Act are most significant legislations in this country towards child safety and dignity. Yet more than a decade after this enactment, we still face real challenges on the ground. Some challenges are like delays in trials, high rates of witness withdrawal, inadequate convergence between the systems, and most importantly, the risk of re-traumatizing the child while seeking justice. Conference rightly places its focus on rehabilitation and reintegration, not as secondary aspects but as central pillars of the justice process. In Telangana, we have tried to respond to these gaps through a unique systemic innovation that Bharosa centers. It was established in Telangana and now it is scaled to 29 operational centers as one-stop crisis response and integrated support system for survivors of rape and child sex abuse. It brings together police, legal, medical and psychological services under one roof, away from police stations and hospitals as is evidently required by the POCSO Act. Every center has a dedicated child-friendly counseling room with age-appropriate material toys, visual tools and calm spaces to reduce fear and anxiety among the victims. Child psychologists and counselors trained in child-specific communication methods as well as medical and paramedical support persons provide key roles during this BNSS statement, medical examinations and helping investigating officers elicit trauma-informed disclosures. Dedicated support persons and legal support staff ensure that child and family are not left to navigate the justice system alone. An enabling ecosystem for POCSO should not be an isolated initiative. It is just enabler for the justice. We now operate one of the country's most advanced child-friendly courtrooms, facilitated through Hyderabad Bharosa Center, where children can depose without entering into so-called intimidating courtrooms environment. Does not have to confront the accused and feel free as well as confident. This is being scaled across all the districts in the state of Telangana. Convergence between Bharosa and juvenile justice system, including CWCs, DCPWs, JJBs and the courts, should grow further to become a comprehensive model for inter-agency collaboration. We have built strong referral system, fast-tracked it, medico-legal processes and ensured timely access to victim compensation as well as established an emergency victim assistance fraud. Despite its progressive framework, the juvenile justice system continues to face some challenges. The convergence between juvenile justice boards, CWCs, police and support services often lacks consistency and structure. Delays in rehabilitation planning, weak legal aid and inconsistent application of child-friendly procedures contribute to gaps in justice delivery process. Additionally, limited access to psychological counseling and slow victim compensation processes hinder full reintegration of child into the society. Observation and children home often are regarded as operating under suboptimal conditions, poor hygiene, lack of medical personnel, inadequate security and limited educational or vocational support. Many homes lack trained staff and structured rehabilitation pathways, leading to emotional disengagement and increased risk of absconding. Weak admission documentation and monitoring systems further compromise child safety and traceability. To strengthen synergy between POCSO framework and juvenile justice system, joint operating procedures and streamlined referral mechanisms must be institutionalized. Cross-departmental trainings involving CWCs, JJBs, police and child welfare staff are essential. Dedicated rehabilitation tracking should ensure continuity of care rescue to long-term integration. Infrastructure and HR upgradation in CWCs and JGBs, along with monitoring indicators for timeless and child sensitivity are critical. Confidential data sharing and prioritizing children's voices and trauma recovery reaffirm that justice includes hearing and dignity, not the conviction. Let the conference be a platform not just for deliberation but for commitment. Let us together reaffirm that justice for children is not just about conviction rates but about restoration, safety and healing. State of Telangana, under the leadership of our Honorable Chief Minister, is committed to strengthening the Bharosa model further and sharing our learnings to contribute to national and state frameworks. We welcome collaboration, innovation and shared vision for all present here. Let us all be together and take care of life and dignity of all people who deserve it. Thank you. Jai Hind.
Thank you, sir, for your special address on this inaugural session. I now request Honorable Mr. Justice Sujaypal Garu, Acting Chief Justice, High Court for the State of Telangana and Patron-in-Chief, Telangana State Legal Service Authority, to kindly illuminate us with your Honor's special address.
Honorable Shri Justice Suryakant Ji, Judge, Supreme Court of India and Executive Chairman, National Legal Services Authority, New Delhi, Honorable Chief Minister Shri A. Revant Reddy, my esteemed colleagues present in the auditorium, the Learned Advocate General, Learned Additional Advocate General, the Shri Jitendra IPS, Director General of Police, Telangana State, Miss Santhya McFray, Representative of UNICEF, Ms. Charu Sinha, IPS, Srimati Anita Ramchandran, IAS, Secretary, Women Development and Child Welfare Department, Shri Panchakshri, Member Secretary, the resource persons, the stakeholders from different departments. Very good morning and welcome to all of you to this very important meet today, where we would like to discuss frankly about the issues before us so that we can come to a conclusion. But before coming to that, I would like your attention on the very, very relevant data which will show us the picture regarding POCSO matters. In December 20, the pending cases in Telangana regarding POCSO were 5267. In December 21, it became 6828. In December 22, it became 10,589. Comparing from December 20, when it was 5267, in December 22, within 2 years, it became almost double, 10,589. In January 23, it was 10,605, and at present data is available up to October 24, where the figure was 8308. This alarming increase is only one aspect of which causes worry. The another aspect and the another data which is more alarming, which is more dangerous, is that 98% accused are either family members, relatives, friends or neighbors. And therefore, in such a situation, a child victim who is subjected to sexual abuse, it is very difficult to withstand the social pressure, and in most of the cases our experience is that that victim turns hostile because of the family and social pressure. In that event, what is very important to record conviction and stop this is the scientific evidence, the other circumstantial evidence. And therefore, the idea to bring everybody under one roof that every stakeholder, the education, the police, the health department, the R&B, everybody who is taking care, who is the stakeholder, should be under one roof so that we can identify the issues and solve the problems. I'll give a very small example that when a child enters a school, her or his name is registered in admission register, we sometimes called as Dakhil Kharij register. A small overwriting in date of birth in that school register can give benefit to the accused if at later point of time that child is subjected to any sexual abuse. Likewise, as I said, that scientific evidence in cases of POCSO are very important. Now the Government of India has come up with a complete protocol of DNA, how to procure a sample, how to keep a sample, in which temperature it is to be kept, what is the shelf life, what is to be taken care of. And there is a judgment of Supreme Court on that, if I correctly remember, authored by Honorable Justice Bela Trivedi. The entire chain, the time from where the sample was taken and how it travels to the FSL and then how the report is prepared, this entire chain needs to be established meticulously. And even one break of chain anywhere ultimately gives benefit to the accused. A checklist can be prepared so that all these possibilities can be eradicated. These are very sensitive issues because ultimately victim is a person about which the organizers have rightly given the name that it is a conference for giving voice for the voiceless. So what my understanding is that in all these technical sessions where the experts and resource persons will address you, please feel free to tell you about your problems in your department which you are facing, and please interact with the resource persons, please interact with the other departments. I'll give a small example of a similar conference in my parent state. A young lady constable stood up in a session and she said that when we take the victim, the child with their parents after the sexual abuse to the hospital, we are required to wait for 5 hours, sometimes for 6 hours because the doctor is busy elsewhere. And it is such a traumatic thing for that small child and their family members that sometimes the family members withdraw their consent for the medical checkup. We discussed it in the conference and the head of the medical department stood up and he said that from Monday itself we will prepare a roster where in every hospital a dedicated doctor will be there whose first responsibility will be to take care of and attend that child. So these are small things, but this makes a difference how we treat the child, how we give her an atmosphere and how sensitive we are. And therefore I'll request all of you that when a file comes before you as a judge or file comes before you in a FIR before a police station or a file comes as a doctor before you, please remember that the word file and life has same letters, L-I-F-E and F-I-L-E, and every file has a life within it, and therefore this session was rightly called as Voice for Voiceless. I'll end with the request that everybody should deal this matter, these aspects with utmost sensitivity. A poet said, अपना गम लेकर कहीं और न जाया जाए, अपना गम लेकर कहीं और न जाया जाए, घर में बिखरी हुई चीजों को सजाया जाए, घर से मस्जिद है बहुत दूर चलो यूं कर लें, घर से मस्जिद है बहुत दूर चलो यूं कर लें, किसी रोते हुए बच्चे को हंसाया जाए. Take your sorrow somewhere and don't let it be seen. Let's arrange these scattered things in the house. The place of worship is far from home. Let's take a walk. Let's make a crying child laugh. Thank you very much.
Thank you, my Lord, for the inspiring and thought-provoking special address on this occasion. May I now request Honorable Sri A. Revant Reddy Garu the Chief Minister of Telangana State to deliver special address. Sir, please.
Honorable Sri Justice Surya Kant, Judge, Supreme Court of India, and Executive Chairman, National Legal Services Authority, Honorable Sri Justice Sujay Paul, Acting Chief Justice, High Court of State of Telangana, and Patron-in-Chief, State Legal Services Authority. Respected members of Judiciary, senior police officers, women and child department officials, legal services experts, UNICEF, civil society and development partners. I welcome you to this state level conference. The theme, Voice for the Voiceless, is very important for our society. I congratulate the Telangana Police and other organizers for holding this conference. We must put child survivors at the center of our legal and moral framework in fighting this heinous crime against humanity. We have to protect our children from sexual abuse at any cost and with all means. My government gives top priority to the protection of children and women. Telangana Bharosa project has 29 centers. It provides police support, legal aid, medical assistance, and counseling in a friendly environment. Telangana pioneered child-friendly courts run by Hyderabad Bharosa Center. The goal is not just faster cases disposal, but total child protection and development. POCSO Act and Juvenile Justice Act are highly progressive instruments in our legal framework, but they come with problems. We must ensure procedure help child victims, not hurt them. We must also end child pornography and impose strict punishments. Social media abuse of children must also be treated without mercy for culprits. Our state government is fully ready to take all steps. We must ensure justice and compassion for children not only in courts but also at police station, child centers, and in every step of this process. I appeal to all of you, respected judges, police officers, CWCs, development partners, let us move forward with a shared mission. Justice is not just about conviction. It is about restoration, about dignity, and reclaiming childhood. Thank you. Jai Telangana.
Thank you, sir, for your valuable message and the steps being taken by the Telangana state government. It is time to hear our today's chief guest, Honorable Sri Justice Surya Kant, Judge, Supreme Court of India. My Lord, please.
Shri MCRHRD, Honorable Chief Minister, State of Telangana, Justice Sujay Paul, Honorable Chief Justice in Action, High Court of State of Telangana, and Patron-in-Chief of the Telangana State Legal Service Authority, Justice Shyam Koshi, Executive Chairman of the State Legal Service Authority, Telangana, my distinguished sister and brother judges of the Telangana High Court, Dr. Jitendra IPS, Director General of Police State of Telangana, Ms. Cynthia McFrey, representative of the UNICEF India chapter, Learned Advocate General of State of Telangana,
Member Secretary Mr. Bharat Parashar of the National Legal Service Authority, Member Secretary of the State Legal Service Authority and other my dear judicial officers, very senior officers of the police department, senior administrative functionaries of the state government who are present here. We also have among us Mr. Santhan Krishnan, Live President of the Commonwealth Lawyers Association, distinguished dignitaries, jurists, statesmen, police officers, social workers, ladies and gentlemen, friends from media. When Honorable Chief Justice cited a very emotional Nazm of Nida Fazli, I immediately recollected Maria Montessori, a very celebrated pedagogue, and what she said about child. I quote her, "It is the child who makes the man, and no man exists who was not made by the child he once was." I think this statement communicates everything with respect to a very serious issue which we intend to deliberate in this one-day conference. These words of Montessori also remind me that the well-being of our children is not merely a moral obligation, it is the foundation upon which all of society is built. The child is not just our future, they are our mirror, our responsibility, and our greatest test. Today, as I stand before you, I cannot help but echo the statement of Montessori, because I am of the firm view that if we fail our children, we are not only failing them, we are failing the very soul of our nation. I therefore wish to applaud the distinguished speakers who have preceded me. Their remarks have incisively addressed many of the urgent and layers challenges in the realm of child protection. I find myself in strong agreement with the issues that Cynthia has raised, or Honorable Chief Justice and Honorable Chief Minister have raised. I see it as both a duty and a privilege to build upon those reflections by offering a perspective grounded in constitutional values, judicial insight, and our shared moral responsibility to the children of this great nation. At the outset, I would like to express my sincere appreciation for the untiring efforts of the Women's Safety Wing of the Telangana State Police and the Telangana State Legal Service Authority in organizing this event with exceptional commitment and vigor. I also commend the United Nations Children's Fund, Madam Cynthia representing, whose pioneering work in uplifting child across the globe is undoubtedly unparalleled. This conference, I believe, is a concerted attempt to confront the silent suffering of the most vulnerable among us, our children. Even today they remain most susceptible to neglect, abuse and exploitation. And in a country like ours, where their numbers are staggering, the stakes are even higher. I rely upon the UNICEF 2024 report, according to which 24% of the India's population is under the age of 14. 1 in 3 Indians is below the age of 18. This amounts to over 345 million children, more than the total population of many continents. These figures, while astonishing, are not merely statistical marvels, they are a moral reckoning. For a nation so young, our greatest asset could also too easily become our gravest liability if we fail to protect, nurture and invest in our children. Potential does not convert to progress on its own. It requires systems, safety, and sustained care. Each child we fail is not just a personal tragedy, but a lost thread in the fabric of our nation's future. This demographic reality places upon us an extraordinary responsibility, one that cannot be met with token gestures or fragmented responses. Every act of abuse, every moment of neglect must be seen not as an aberration, but as a collective failure. If we neglect our children, we forfeit the very future we hope to build. We must consequently confront what we are often too afraid to name, the child sex abuse. Make no mistake, this crime does not occur only in dark alleyways or distant corners. As Honorable Chief Justice rightly pointed out, it happens within homes, schools, neighborhoods and institutions. Places we instinctively consider safe. It is a violation that hides in plain sight. And it is not only a criminal act, it's a betrayal of trust, of childhood, and of the constitutional promise to protect our most vulnerable. It makes a grave failure of our collective guardianship, and if I can say, it's also a failure of the state's parents' patriarchal responsibility. What makes this abuse especially heinous is that its harm runs far deeper than physical injury. Its wounds are often invisible but lifelong. Fractured self-worth, chronic anxiety, depression, PTSD, and tragically, you must have seen sometimes even suicide also. But the long-term damage goes even further. Research increasingly shows that children who suffer such trauma are more likely to become withdrawn, economically marginalized, or emotionally unstable adults. Worse still, there is the risk that some may perpetuate the very cycles of abuse that once endured. These are the outcomes no enlightened society can afford to ignore, and therefore we need to be over-conscious about it. The law is enacted, of course. We have the 2012 Act, which is a very robust legislation. It brought a long overdue legal overhaul, which is gender neutral, comprehensive, and child sensitive. It recognized perhaps for the first time that the justice system must be adapted to the child, not the other way around. But a law is not only as strong as its implementation. Special courts remain unevenly distributed. Police forces are often undertrained in trauma-informed investigation. Schools rarely speak about consent, autonomy, or safety. And even in judiciary too, we are insufficiently sensitized to the unique vulnerabilities of the child victims. In light of these realities, the path forward must be carefully and compassionately charted. There is where the agenda of this conference becomes so vital. As a lifelong student of law, I have experienced firsthand how even well-meaning systems often place disproportionate emphasis on punishing the perpetrator, while the child, whose life has been irreversibly altered, is left unheard, unsupported, and often re-traumatized by the very mechanisms meant to help. Justice becomes synonymous with conviction instead of recovery. If some of you will recollect, in 2014 onwards, I have been speaking about invisible victims of system, and that is what precisely I meant to say. Consider the case of a 10-year-old made to recount her trauma repeatedly. Before whom? To a teacher, a police officer, a medical examiner, a lawyer, and then a judge. With each retelling, her voice grows fainter until it vanishes altogether. This cannot be called justice. It is distress compounded by process. When the system forgets the child in its pursuit of the accused, it fails them both. This imbalance is not incidental, it is structural. That is why the focus on rehabilitation at this conference is both timely and necessary. Our child protection framework, though well-intentioned, remain disjointed and under-equipped. What we need is a fundamental shift, one that sees the child not as a passive witness in a criminal trial, but as a person in urgent need of sustained and holistic care. True justice for a child begins not in the courtroom, but in the moment they feel safe and secured within and outside the four walls. It begins in the hands of a counselor, the embrace of a caregiver, and the assurance that they will not have to walk alone. Reintegration must not be an afterthought. It must be the foundation of our response. Because a child's healing is not just a legal requirement, it's a moral obligation. And in this context, and knowing the Indian, our societal background, it is a constitutional commitment also. As we look to the path ahead, one truth becomes abundantly clear. The task of protecting and supporting child victims is far too important to be left to the legal system alone. Not only is it a responsibility of the judiciary, police or social workers, it is in fact a collective national duty. Every institution, every stakeholder, and indeed every citizen has a role to play in creating an ecosystem where children are safe, heard and helped. We must move away from reactive justice to a more proactive, compassionate model where rehabilitation is not a footnote but the foundation. In this regard, I would be remiss not to acknowledge and commend the pioneers' efforts initiated in the state of Telangana and particularly in the city of Hyderabad. As the Director General of Police explained, the Bharosa centers here have really emerged as a model of what integrated, victim-centric support should look like. By offering a one-stop facility where child and women victims of violence can access police assistance, legal aid, medical care and psychological counseling under one roof, these centers exemplify what sensitive and holistic justice delivery should aspire to be. They demonstrate that with the right vision and commitment, it is possible to ease the child's journey through the justice system, minimizing the pain and agony and maximizing the care. Similar appreciation is due to the NALSA's novel child-friendly legal service scheme of 2024, which envisions a trauma-informed, child rights-driven ecosystem. It is not only ensures courtroom dignity but the provision of psychological care and compensation to the victim. It is my earnest appeal that such best practices be assimilated and adapted across the length and breadth of the country. Whether it is the level of the state policy, institutional design or community intervention, we must commit to replicating and scaling such models. Let us therefore take inspiration from what has worked and build upon it, ensuring that no child anywhere in India is left to navigate trauma alone. In doing so, we not only uphold the letter of the law, but the spirit of our Constitution, which promises every child the right to dignity, safety, and opportunity. I would like to conclude at this juncture by briefly alluding to the words of a stalwart of human rights, Nelson Mandela, who once rightly said, and I quote, "There can be no keener revelation of a society's soul than the way in which it treats its children." Ladies and gentlemen, our work is far from complete until our children experience meaningful restorative justice, where the systems meant to protect them do not re-traumatize, and where their healing is prioritized outside along with accountability. This conference has brought together a range of voices, legal minds, administrators, caregivers, jurists, and protectors united by a common purpose. But beyond the deliberations and draft recommendations, that's my humble submission, we must take back with us a renewed sense of moral urgency. Laws, however well written, are only as effective as the compassion with which they are implemented. Systems, however well structured, are only as just as the people who operate them. Strengthening the POCSO framework and child protection ecosystems will require vigilance, innovation, and above all, empathy at every level. Let this conference, therefore, mark a turning point not only in the policy but in a national consciousness. Let us vow that no child will be made to feel that their pain is a footnote or that their dignity is conditional. Let us make our nation not merely compliant with law but radiant with justice, for it is in the safety of our children that the soul of our republic truly lives. Thank you very much. Thank you for giving this opportunity. Jai Hind, Jai Bharat.
Thank you, my Lord, for enlightening us on different aspects and need for the POCSO Act and enriching us with words of wisdom, which I am assured that they will guide us in the days to come. Indeed, it is a distinct honor and a privilege to have amongst us Honorable the Judge, Supreme Court of India, and the Executive Chairman, National Legal Service Authority, whose august presence has illuminated today's consultation meet on the topic of voice for the voiceless and rights and protection of children of sexual abuse. We would like to take this opportunity to express our gratitude by felicitating the dignitaries on the dais for their generosity and kindness in gracing this occasion. For this, I humbly request Honorable Sri Justice Sujay Pal, Acting Chief Justice High Court for the State of Telangana and Patron-in-Chief Telangana State Legal Service Authority, to kindly honor His Lordship Honorable Mr. Justice Suryakant, Judge, Supreme Court of India, and Executive Chairman, National Legal Service Authority, with a shawl and a memento. Thank you, my Lord, for accepting the felicitation. Now, I humbly request Honorable Sri Justice P. Sam Koshi, Judge, High Court for the State of Telangana and Executive Chairman, Telangana State Legal Services Authority, to kindly honor our Honorable Sri A. Revanth Reddy Garu, Chief Minister, Telangana State, with a shawl and a memento. May I now humbly request Honorable Srimati Justice Maushmi Bhattacharya Madam, Judge, High Court for the State of Telangana, to kindly honor our Honorable Sri Justice Sujay Pal Garu, Acting Chief Justice, High Court for the State of Telangana, with a shawl and memento. Thank you, my lord. Now I humbly request Ms. Charu Sinha, Additional DGP, CID, Women Safety Wing, Hyderabad, to kindly felicitate Sri Dr. Jitendra IPS, DGP Telangana, with a shawl and memento. Now I humbly request Sri Dr. Zelalam B. Tafassi to kindly honor Madam Cynthia McCaffrey, representative of UNICEF India, with a shawl and memento. Thank you, madam. With this, we have arrived towards the end of the inaugural session, and before winding up, I would like to request Srimati Srijana, Women Development and Child Welfare, Telangana State, to kindly propose vote of thanks. Please, ma'am.
Namaskar to every dignitary, guest and participant gathered here. Today, we stand united by a cause that transcends profession, politics and power, protecting the innocence of our children and giving them a safe childhood. On behalf of the Telangana State Legal Services Authority, Women Safety Wing, Department of Women Child Development and UNICEF, I express our deepest gratitude to Honorable Justice Suryakant Garu, whose presence reaffirms that the highest court of our land remains a steadfast guardian of child rights. We are inspired by the commitment of Honorable Chief Minister Revant Reddy Garu and the Honorable Acting Chief Justice of Telangana, Shri Sujay Pal Garu. Their leadership sends a strong message that justice for our children is not optional. It is urgent and non-negotiable. To DGP, Dr. Jitendra sir and Ms. Cynthia McCaffrey, we are grateful for your voice and your action. Your work reminds us that systems are strengthened when hearts lead the way. To the judges, officials and partners, activists, thank you. You are the architects of change and the silent warriors who protect those who cannot speak. As we step into the technical sessions, may our collective voices echo louder than the silence and our shared action be the bridge between the law and justice. Thank you. Jai Hind.
Thank you, ma'am. Now I seek the permission of the Honorable Chair to declare the inaugural session is closed. Thank you, my lords. The inaugural session is declared closed. I now request all the dignitaries present on and off the dais, all esteemed guests, participants and everyone present in the auditorium and who are witnessing this inaugural session virtually to kindly rise for national anthem.
Janagana mana adhinayaka jaya he Bharat bhagya vidhata Punjab Sindh Gujarat Maratha Dravida Utkala Vanga Vindhya Himachala Yamuna Ganga Uchchala Jaladhi Taranga तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you, my lords. Lunch is arranged for the participants at Tungabhadra Trupti Hall, and for the VIPs adjacent to this auditorium, I request all the participants to join.
guilt is entirely dependent on whether the victim is below 18 years of age. I think section 2D of the POCSO Act defines child, and I think it's section 221 or something of the JJ Act which defines a child. Everything, I mean, about below 18 years of age. So presumption of guilt actually under section 29 requires the court to treat as the first foundational fact as to whether the victim was below 18 years or not. Because if the victim is above 18 years, then of course the entire mechanism of the criminal procedure trial that changes, and there is no presumption of guilt under section 29. But if the victim is of course below 18, then the entire presumption of guilt arises under section 29. And then if you see from the POCSO, if you go shift your gaze to JJ Act, you'll find that section 15 of the JJ Act talks about presumption. You know, it can be through visual appearance, it can be through interactions with the offender, with the or the child or the person who has suffered the offense with the JJ board. But it is actually section 94 of the JJ Act which lists these three, I think section 94 1 or 2, but it has these three ways of determining age. Number 1 is school certificates. Number 2 is certificates from the corporation, municipal corporation. And number 3 is the ossification test. And you know, when I was doing a little bit of reading actually last night, I came across these this one technique which is being used now by the US immigration authorities. You know that there is huge thing going on under the President of the United States policies that, you know, immigrants should be sent back, etc. They've come across this test called the wisdom teeth test. And that wisdom teeth test is the third molar tooth, which usually sprouts between 17 and 25 years of age. And they feel that the margin of error in the wisdom teeth test is much lower than the bone ossification test. The second, the recent technique which I came across is called the epigenetic clock. The epigenetic clock test. That actually measures the age using the age of DNA and the age of, the methyl conditions of DNA, that how old is the particular tissue in the body of the victim. So can you imagine how advanced and how scientific these tests have become just in order to determine age. And under the POCSO, you know that it is so important to determine the age of the victim so as to not only sometimes protect the rights of the accused, but also to bring the accused under the book because of section 29, the presumption of innocence. And in a 2022 judgment of, I think, authored by Justice Pardiwala, it's called Shubham Sankra 2022. I've forgotten the citation. There the Supreme Court also took into account the ways of measuring of age determination under section 94 of the JJ Act, read with section 15 in some circumstances, and saying that, you know, visual appearance of a child or visual appearance how a person looks is, cannot be a determinative factor, and it can be full of error, and therefore specialized tests must be developed to determine age. And the last, of course, I'll just one line on that, is the cyber crimes. You know that now children are, the biggest victims of cyber crimes, whether it's child pornography, whether it's morphing the image and using the particular child's face, and it is so quick, it is so heartless, and it does complete and lifelong damage to the child. So before, I'll forget to just quickly in 1 minute show the slide, so that, since I've spent some time on it, so might as well show it. So just the convergence, I've already spoken about these things. That's the JJ Act, the POCSO Act, and the BNSS, and the difference as well as the convergence in these three acts. Then the definition of a child and victim under the legislations. You have the sections under the JJ Act, POCSO, and the BNSS. And I'm quickly going through it, but it's with Mr. Panchakshari, so he can share it with anyone who's interested. It's just 8 slides. Then we have the victim-centric approach in the law, and again under that you have the JJ Act, POCSO, and BNSS, and how is the victim treated under these 3 acts. So I've just tried to also include children with disabilities, which is very important now, because that they should receive special care under every circumstance, and accessible procedures which are available to children with disabilities, and that is covered under the POCSO as well as the BNSS. And then of course you have the victim compensation under the law. I've discussed about it, the BNSS, the POCSO, and the JJ Act. The sections, I've just mentioned the sections. For all those of you who are not lawyers, but it's not important to remember the sections, just how the Act deals with these issues. Then, of course, the importance of age of child. I've spoken about this, that why is age so relevant and should be the focal point in POCSO cases. And medical examination. Under Section 27 of the POCSO Act, what are the rights of the victim? What is the procedure to be employed for the medical examination of a child? And role of special courts in POCSO cases, very important. Many of you here have handled these cases, many of my colleagues have. So Section 828 of the POCSO, what does it envisage? I'm just quickly going through. You can have a look at it later. And visual assessment, never enough. It cannot be a complete determination. And reasonable doubt about age of the child, Section 94, it's 94.2. 94.2, 1, 2, and 3. What does it mean if there's a doubt? What can the court do? Are there processes for the court to employ if there is a doubt? And yes, about the wisdom teeth technique and the epigenetic clock, which I just spoke about. And that's, yes, that's State of Jammu and Kashmir versus Shubham Sangra, 2022. That's the Supreme Court decision, Justice Pardiwala sitting with Justice Rastogi. Yes, so that's about it. Thank you, and I'll very happily give the mic to my my specialist panelists, who will be giving you the ground level experiences of what they have come across. Thank you.
Dignitaries on the dais, Justice Mosumi Bhattacharya, Srimati Rema Rajeshwara Garu, Sri Pagadala Ashok Garu, dignitaries of the dais, the Honorable Judges of the High Court, District Judges, and judges of all cadres, and police officers of different cadres, the stakeholders of POCSO, my pronouns to one and all. The topic assigned to me for this technical session is age in POCSO cases, the complexities in determination of POCSO cases. Really, at one time, it was very challenging. Of course, still also it's very challenging. It's not only interesting, but also challenging. It was more challenging, and it was an emerging issue while we were the initial judges of POCSO courts. Those were the days when we were the initial judges of POCSO courts after the advent of the Act 2012. But now, there is no res integra. Everything is tailor-made, thanks to the judgments of the Supreme Court from time to time and various high courts. So within the time constraints, I would like to deal with some of the judgments of the Supreme Court and various high courts. To make the point so simple, there is nothing to be worried. I make it clear, nothing to be worried, and this controversy is set to rest. See friends, age of a child. So we have to see from two different angles. First is age of a child as a victim. Age of a child as a victim. And the second thing is age of a person on the other side, whom you call it as a juvenile within the meaning of the word juvenile under Juvenile Justice Act 2019. And also the other category of a juvenile or CCL who can be treated as an adult for the purpose of trial by Children's Court after the opinion expressed by Juvenile Justice Board within the meaning of section 14(3) read with 15 read with 18(3) of Juvenile Justice Act. So these things you have to pay consultation. The first thing is taking a child as a victim. This is of a victim. And this is the other side, that is, you call it as accused, you call it as juvenile, or the third category as CCL being treated as an adult for the purpose of trial by Children's Court. The special category coming under 14(3) read with 15 read with 18(3) of Juvenile Justice Act 2012. How to resolve it? Second category, this is of a juvenile. And of three categories, I already mentioned three categories. So coming to victim, coming to the accused, coming to child as a victim, the Honorable Justice has just now said, child is defined under the Juvenile Justice Act, 2 Class 1D, as a person below the age of 18 years. Below the 18 years. It goes in line with the same definition given for child under the Juvenile Justice Act 2019 and also previous JJ Acts also. Now under the BNSS also, and of course BNS also defined a child. 2 Class 3, it has also given the same meaning. A person below the age of 18 years is called child. So under 2 Class 1D of POCSO Act, child is defined as a person below the age of 18 years. Then a controversy arose till 2017, till the advent of a judgment of the Supreme Court. There is a controversy. Which age of the child? Is it biological age, chronological age, physical age, or mental age? A judgment of the Supreme Court by two giants of the Supreme Court, that is ERA through Manjula Kripendor versus State NCT Delhi. 2017-15 SCC, page 133 is the page, you may note. 2017-15 SCC, page 133 is the judgment. 15 SCC, page 133 is the judgment. It is ERA through Manjula Kripendor versus NCT Delhi. Facts of the case, of course, though I am aware of the time, I have to necessarily tell you the gist of the facts. There, ERA, a child, represented by her guardian, mother, Manjula Kripendor. She was of 38 years old. Physically, she was of 38 years old. But she was suffering from cerebral palsy, a disease under which her mental age is not more than 6 to 8 years. That was a controversy. So up to the stage of Delhi High Court, her mother was successful in getting her treated as child within the meaning of Section 2 Class 1D. But when it came to Supreme Court, this judgment, the Supreme Court, delivered by two eminent judges of the Supreme Court, Justice Deepak Mishra and Justice F.S. Nariman. Both of them have delivered their independent their judgments of two different judgments, but both of them have given concurrence at the core of the issue. So, Deepak Mishra's judgment, of course, he relied upon the doctrine of causes omissus. Conscious omission. What he opined is, when the legislature has consciously omitted a thing, that should not be supplemented by its courts, unless there are special circumstances to justify the same. The court should not make such an interpretation unless or until they are called for, that is warranted. He opined, because the legislature purposefully omitted it. Mental age, they did not use the word mental. It doesn't apply to the mental age. It's only physical age. When it comes to Nariman, he relied upon the doctrine of Lakshman Rekha. He said, the courts have got certain limits. Legislature, they should not usurp into the ambit and sphere of the legislature. So both of them have given concurrence on the core point that it is only physical act, chronological act, biological act, but not mental age. So it is put to rest. There is no controversy now. It's only physical act, physical age. Then another question arose. Immediately another question. How to determine then? Because you know, the POCSO Act is complete code. POCSO Act is complete code because it contains the provisions of both substantive law as well as procedural law. If you see the provisions right from chapter 5, they contain both substantive act as well as procedural laws. It's quite independent. The act is quite independent. It's complete code. Then for determination of age of child, there is separate section 34. Section 34. Section 34 says that it is the judge of the POCSO court who has to determine it. Unlike the other courts which may send the record to the Juvenile Justice Board for determination, isn't it? But here it is a complete court. It says that it is a special court that has to determine. That is under 34. Then again arose some controversy. Because first two sentences of the section reads, suppose if you observe first two sentences, section reads that for determination of age of a person who committed the offence, that means CCL, child in conflict with law, first two sentences. So then, does it apply for determination of age of a victim? If you read the section, you will be carried away by first two sentences that is applicable for determination of age of a person who committed the offence. That means you call him a CCL. So does it apply to determination of age of a victim? And then what is the procedure to adopt the inquiry? Is it laid down anywhere? POCSO Act is silent. Rules under the POCSO Act, now recent rules of 2020, they are silent. So where to find? Section reads that same procedure that is applicable under JJ Act, that is applicable. Same procedure that is applicable under JJ Act, that is applicable. Where is that procedure? JJ Act of 2015 now. The procedure on section 94. JJ Act of recent Act of 2015. The procedure is under section 94. When it was JJ Act of 2005, the procedure under Rule 12. When it was JJ Act of 2000, the procedure under section 7A. That is clarified by the Supreme Court. I will tell you, I will give you the citation. These two. Previous Act 2005. Where is the procedure? The procedure under Rule 12 of JJ Rules 2007. Then it was POCSO Act of 2000, JJ Act of 2000, the procedure under section 7A. This is the same procedure that is now. Then does it apply for determination of age of a victim? There is judgment of Alok Singh's case. The Supreme Court clarified it, Alok Singh. Of course, prior to that, of course, there is judgment of Jarnail Singh's case. Alok Singh's case, there is sufficient. State of Maharashtra versus Alok Singh. State of Maharashtra versus Alok Singh. 2015, 7 SCC, page 772 the citation. 2015, 7 SCC, 772 the citation. You may note down. In fact, of course, I asked them to arrange the same to display it. Monitored, of course, but they could not find time. Otherwise, I could have displayed. I brought the pen drive also. That's why I'm telling the citations. You may kindly note down. 2015, 7 SCC, page 772 the citation. State of Maharashtra versus Alok Singh. There, the Supreme Court, it clarified the same procedure that is applicable for determination of age of a juvenile. Alok Singh, that's the citation. That is also another judgment, madam. Jarnail Singh's case of 2013 is of 2015. 2015, 7 SCC, page 772, madam. Yes. There, of course, then the same procedure that is applicable. Then what the procedure then? How to prioritize things? How to determine? Section 94, just now, our Lordship just now said. It is categorized into different priorities. The first priority is to look for the date of birth mentioned in the matriculation certificate or any other academic record. The first priority is to look for any academic record, just like SSC certificate, matriculation or something else. First priority that should be given. 94. First priority is to look for matriculation certificate or any other. Second one is, suppose victim could not produce all these, or guardian could not produce all these things. Then second thing is, any date of birth certificate issued by corporation or municipality. Second priority is, any date of birth certificate issued by a corporation or municipality. Suppose victim is illiterate. Victim could not produce any of these two. Then what is, how to determine? The third category is to go for ossification test, radiological examination, or any other scientific method, scientific new invention. That's just like our Justice Bhattacharya just now said. The scientific inventions, new scientific methods that can be adapted. Ossification test, that is known to us. And second one is radiological examination, that is also known to us. Dental examination, all these things. And any other thing that can be invented in course of time, because we cannot rule out, because till 1953 we were not aware of DNA. Prior to 1953, when DNA was not invented, we were not aware of DNA, but now we are using DNA. That may come. So that's why they mentioned it clearly that any scientific method that is developed from time to time, that can be adapted. Then immediately comes the next question. To whom the error of margin should be given? Suppose you go for radiological examination, go for ossification test or something, some scientific method of determination without going for this certificates, medical, education certificate, other certificates issued by corporate, other things. Then to whom the error of margin should be given? There was much confusion, much inconsistency between courts. Some single judges, they held in favor of victim. Some they held in favor of the accused. Because some of them developed the view that it is the object of the act. It is designed to give the benefit to the victim. So it should go in favor of the victim. Some said, no, it should go in favor of the accused. But luckily for us, there are two judgments. One is of Supreme Court, and other is of Delhi High Court reference. They set the controversy to rest. The recent judgment, 2024 SEC Supreme Court, Delhi Online 4484 is the judgment. 2024 SEC Online Delhi, page 2284 is the judgment. Court on its own motion versus NCT Delhi. The citation is court on its own motion versus NCT Delhi. Two judges. They elaborately discussed it. they were lucky enough to have the guidance of the Supreme Court. Rajak Mohammad's case. Rajak Mohammed versus State of Himachal Pradesh is the judgment. 2018, 9 SEC page 248 is the citation. 2018, 9 SEC page 248, they decided. Rajak Mohammad's case. They said that error of margin should be given to the accused because we should not deviate from the fundamental canons of the criminal jurisprudence. They dissolved. So here, of the latest reference answered by Delhi High Court, they clarified that the benefit should be given to the accused but not to the victim. So far as the victim is concerned, everything is clear, isn't it? Then coming to the other side of the coin, some controversy here. Recent Qatar's judgment, of course. They have also elaborately discussed all these things. First thing is Siddheswar's case. Siddheswar versus state Hastur police station. Siddheswar versus state of Karnataka, of course, and the Hastur police station. The 2016 ILR 4203 is the citation. There, again they made the discussion on 94, and again they made the discussion on Rule 12 under JJ Rules 2007, and again on Section 7A under the JJ 2000. So same thing. How to determine the age of a juvenile? Same procedure under Section 94. So a question arose now. Another controversy arose. Suppose in one case, what happened is, it's a very interesting case. There, the victim and victim's guardian, they created some false record. So, education certificate produced by them are the fake records. That was the allegation of the prosecution. Of course, they didn't agree. That means it was tampered record, so as to give the benefit to the victim. Then, under 15.3, that case falling under the 14.3, that with 15, that with 18.3 of Juvenile Justice Act, in between the age of 16 to 18 years. There, of course, you will see 15 says that the determination should be done within 3 months. But here what happened, the prosecution was initiated against these two people. A CC was registered. It may take time. So, is the period of 3 months, is it recommendatory or mandatory? That was the question. Supreme Court clarified. Of course, I will give the citation just now. And they said that let the prosecution be done, but simply because it may result in some time delay, that benefit should not be denied to this juvenile. You may kindly note down this citation. And this is important, that's why I am referring. First thing, Siddheswar, you have noted this. Siddheswar, they have relied upon Shahnawaz case, Supreme Court citation. Shahnawaz versus State of UP, 2011, 13 SCC 751. Karnataka High Court, they relied upon the earlier judgment of Supreme Court, that is Shahnawaz versus State of UP, 2011, 13 SCC page 751. This case, please read this judgment. Kulai Ibrahim, Elias Ibrahim versus State Inspector of Police, BI Bazaar Police Station, Coimbatore. 2024, very recent judgment. 2024, 12 SCC page 332. Justice Ranjan P. Desai and Justice Madan Bilokur. Kulai Ibrahim. The difficulty is they could not arrange, sir. Otherwise, they would have shown it. Okay, I will write, sir. Thank you. I will write. This is 2024. 2024. 12 SCC 332. Kulai Ibrahim, Kulai Ibrahim, alias Ibrahim versus Inspector of Police, State through Inspector of Police, BI, Bazar Police Station, Coimbatore. 2 judges of the Supreme Court. Of course, the controversy falling under 14.3, read with 15, read with 18.3 of the JJ Act. Here, of course, there was one difficulty. Friends, I would like to clarify. Recently, of course, I answered some session arranged by Amravati High Court. There I had sufficient time. I could deal with the session 1.5 hours. There I fielded so many questions. But here I'm having some restraint. I can't speak more than this. There they raised these points. Where to keep the accused? Suppose POCSO judge is a man who crossed 16 years, 17 years. He is produced with the POCSO judge. Where to keep him? That of course, that 19 and 20 of JJ Act. You have to keep him in a place of safety. There the section reads, you have to keep them in a place of safety. You should not send him to jail. Though it's a children court is nothing but POCSO court. He is not a juvenile. He is declared as adult who can be tried as a, who can be tried with a children's court. That's the finding given by the Juvenile Justice Board. You may differ. You may pass an order 19.3. You may differ. You may not agree. Children's court, you may not agree. You may send back to the Juvenile Board. We accepted it, then you have to try him. But where to keep him then? Then place of safety as mentioned section 19 of the Juvenile Justice Act. Suppose he crossed 18 years, can he be sent to the jail? Again section 20 operates. So there are all these, of course, complexities, they appear so ostensibly, they are all put to rest. This is what I want to impress upon. There are judgments, so many judgments. Read them thoroughly, of course, everything is so simple. There is no controversy now. Thank you, thank you. Thank you, friends, for listening to me. Thank you.
Thank you very much, Mr. Bhupati, for giving us so many citations and so many cases, decided cases. I'm sure all of you have taken them down, and if you are interested, you can look up the citations with regard to the controversy of age determination, one of the most important topics. So I'm really sorry, Mr. Bhupati, for hurrying you, because we still have 2 more speakers, and we would love to hear from them, from their own lived experiences. So, can I pass on the mic to Ms. Srimati Rima Rajeshwari, who will give she was a very important addition to our Juvenile Justice Committee and did wonderful work. So, we would love to hear what she has to say. Thank you.
Esteemed officers, Honorable Justice Moshini Bhattacharya, and my fellow panelists, Honorable Retired District and Sessions Judge, my colleague Ashok, and all the distinguished guests, especially justices from the Honorable High Court of Telangana, and all the participants. A very warm welcome and also good afternoon to all of you. We are also partners. We are a very important stakeholder in this 2 days national consultation that is happening with a lot of focus on children and their rights and the wide ambit of crimes being committed against children. Because of lack of time, I'm not really going into all the stories that I brought with me. Very quickly, I'll show the presentation with a focus on what exactly we do at the Women's Safety Wing. I stand here as a representative of the Women's Safety Wing of Telangana Police with the permission of our ADG, Ms. Charu Sinha IPS, who has been a guiding force for us in terms of bringing a lot of focus on this subject. And also I've had the good fortune of being guided by Justice Bhattacharya ma'am and also Justice Nanda ma'am, being a member of the Juvenile Justice Committee for the past 1 year or so. Women's Safety Wing has actually received a lot of guidance from them. We started looking at the issue holistically, which was kind of not there before. For the past 1 year, a lot of important initiatives have been started. And earlier we would only look at case monitoring, we would only look at the different stages of case, especially cases against children. But now, having learned a lot from the Juvenile Justice Committee, now we go into a lot of other aspects also, how these children are being cared for in the institutions in coordination with the WCD department, with great guidance again from Anita Ramachandran ma'am. And the SLSA, Panjakshri Garu, has also been quite supportive in that regard. So it has given us a lot of, opportunities to learn and look at the issue holistically. So before I go into the presentation, very quickly I would like to mention about something, a very important step that was taken by the National Human Rights Commission and eventually in one of the important judgments of the Honorable Supreme Court of India. If you remember, in October 2023, the National Human Rights Commission took a very important decision. They thought this is time that we should give a very clear and concise guidelines in terms of tackling this issue. We've all heard about child pornography. We've heard a lot about the different kinds of crimes being committed against children, in both physical and also in the digital space. But not much awareness was there among the public. And if you look at the police officers, especially the practitioners within the criminal justice system also, there was no deeper understanding of the issue at hand. So in 2023, I should especially thank David from UNICEF for bringing a lot of focus on this issue and also educating us in the process. So this is a very, very important document for all of us to have. This should be a very this should be an important reference point for all of us to start looking at this issue going forward. So they said that any child, if a child's normal childhood is disrupted by any means, it can be a crime or it can be an exposed vulnerability or it can be an act which is actually infringing upon the normal childhood of a child, it is as good as violation of the basic human rights of that child. And with that, they gave this important document and they told us what exactly we are supposed to do. And eventually, Government of India got into a memorandum of understanding with the NECMEC, the National Center for Missing and Exploited Children. It's actually a non-profit organization based out of United States, and they've done a lot of work in terms of keeping children safe in the digital space, especially the dark web, which we keep reading about in the mainstream media. So after the MOU was signed, we started getting this, the CTR reports, the child, tip line reports, which is being shared with all the state police organizations through the National Crime Records Bureau. So basically the MOU was signed between NECMEC and NCRB. So today in India, every time there is a crime committed against a child online, if it is reported either by the victim herself or himself or by an interested party or through a public, a lot of preventive actions are being taken by different police organizations. So if we receive any input regarding a crime being committed against a children in the online space, action is immediately initiated. And earlier, if you look at the timeline that was given to all these intermediaries, all these social media companies, we call them intermediaries, it was almost 36 hours. For example, a child's, compromised pictures are being posted online and a case is filed and the law enforcement agency addresses a letter to the intermediary. It can be Instagram, WhatsApp or Facebook. And if they don't take down the content within 36 hours, they are liable to be punished or we can initiate action against them. But now the NHRC guidelines clearly says that this 36 hours is like way too long. it should be brought down to 6 hours, because I'm sure you must have, being practitioners of law, many of you must have encountered cases where children actually go through unexplainable suffering whenever such incidents happen. I'm going to go into the details of it. I'll be giving you the various types of criminal activities which are being committed against children online. But it's very difficult to explain the kind of trauma a child goes through once this basic rights or privacy is violated. So with this, I'd like to start my presentation. Can we move on to it? So see, when we started the technological revolution in the late 90s, and eventually around around 2014 and 15, when we started embracing digital India revolution, we had absolutely no idea about the flip side of the whole thing, right? See, today India rides high on this honor that we are probably one of the largest, being the most populous country, we are probably having one of the largest population which is online, and the digital India revolution is being spoken about with a lot of pride and honor. But on the other side, there was this issue which was brewing, and in this internet, which is actually looked at as a positive social force for becoming an enabler for growth, becoming a multiplier for growth and development, was also being used to commit crime against children. I'm not going into the crime against women at all, because today we are only focusing on children, crime against children, and it was leading to significant harm to a very important target population of our country. So we missed out on that crucial aspect, but better late than never. For the past 6 to 7 years, Government of India and all the state police organizations have done a lot of activities to address the issue holistically. So today, if you look at the percentage of children who are actually online, I mean, this figure is almost 2 years old. I mean, I couldn't have the latest figures. 97% of the children between the age group of 5 to 17 are online, literally all the time. Very recently, I was home. I went to Kerala to see my parents, and we were having a family dinner, and one of my cousin's wife has a 3-year-old, and the child just simply refuses to eat, and she just gives the smartphone and the child starts eating, and the child is not even looking at the mother, neither looking at the father, neither looking at the the grandparents. The child is just literally, the head is just into the device, right? And if you remember, when we were children, when we were growing up, if you don't eat, what the mother or the grandmother used to say, what did they say? They would just say that khao nahi to police aa jayega, right? But I mean, I think we really have come a long way. We really have come long way, that the child is it was a slap, yes, same ma'am, but the add-on was the fear of police. So but things are, we've come a long way where the child is totally oblivious to what is happening in the surrounding. There is no social interaction, the character formation and the character building is not happening properly, and the parents, being busy, most of them are career professionals, and they live in nuclear families, there is no social support, they just totally leave the responsibility to the mobile phones. And there's a lot of lack of understanding. There's a huge, the issue of ignorance among the parents and also among the teachers about this potential risk which are awaiting these children in the online space. So as per one of the reports published by NECMEC, because every year they come up with this report was accessed for the year 2022 and 23. 22% jump was there in crimes committed against children online. And unofficially I tried to collect some data, and this figure is almost going to be 40-45 for this year. So it is a big number. So very quickly I'll tell you about some of the types of cases that we encounter, we come across as part of as part of the She Cyber Lab that we run as one of the modules in Women's Safety Wing. Cyber grooming. You see, this is a very important issue. This is a reflection of what is happening in today's society, right? So back in those days, who used to groom a child? It's either an uncle or grandparents or the peer group, some friends or some people, the neighbors, or some people in the locality. Today this whole grooming process happens online. every child is active in, at least more than 2 social media platforms. And today's kids are like, this is an Insta generation, right? They're all like, they call it gram, Instagram. The Gen Z calls it gram. They are a gram generation. Their interaction, their social interaction happens more online than in the physical space, right? I think the very limited, the time interval where they actually talk to fellow human beings is when they are actually in school, or if they are into some sports activities or some extracurricular activities. All other times they are actually into the, they are hooked onto the mobile phones. So cyber grooming happens when somebody befriends a child with an intention to commit sexual abuse against this child victim in the future. The second type of crime that we have encountered is cyber stalking. This is really widespread. If you must have read a lot about the she teams that we have in the state of Telangana. It's one of our flagship initiatives, and Telangana police received a lot of praise across the country for this particular initiative called she teams. So in 2014-15, when we started she teams, we were only handling issues of eve teasing, crimes committed against women in the public space. The goal was to keep the women and children safe in the public spaces, right? But today, when we look at the kind of complaints which are being received by these she teams, most of them have something to do with online space, and most of these complaints are received from young adolescent age group, especially girls studying in like 9th or 10th or inter first, second, or in junior colleges. And the kind of, if you look at the number of complaints which are being received, and mind you, this is only I'm only talking about the number of cases which are actually coming to the notice of the police. And what happens in a society like ours, even today, in spite of all the strides that we have made, all the development and the progress, even today going to a police station is a stigma. Okay, it's not really a socially acceptable thing to go and report something to the police station, at least in the rural areas, right? So we are looking at something which is actually really big, and through a wider community outreach, we really have to address this issue and educate the parents and the teachers, especially the teacher community, about these issues. Cyberbullying. Earlier, we would receive complaints that, a boy approached me. He wanted to be he wanted me to be in love with him and like marry him, but I refused, and he's not letting me go. He's like following me wherever I go. But today, this is happening online, right? Earlier, if you just say no to a boy, refuses to meet him, then it just stops then and there. You can take adequate precautions not to be in the same place where the boy is. But today, when you're online, when you have WhatsApp, when you have Instagram and Facebook, it is literally difficult. It's becoming quite hard for these, young age group to stay away from these, perpetrators. We receive complaints of, girls getting abused, and, I have gone through that language. It is extremely abusive. So the kind of mental trauma these children go through, it is quite easy for us to book a case and take up investigation and probably initiate legal action against the person. What about the mental trauma the child goes through, the girl goes through? And sometimes when parents come to know about these issues, the girl child is not allowed to continue the education. So we are actually looking at a bigger social issue. Sextortion. This just does not stop with children. Today this issue is quite widespread. I have received complaints from even educated people, a lot of senior officers, many acclaimed professionals in the society, that you are busy. We are always busy. You have the phone in the hand, and sometimes you get a call. Sometimes it's a video call. Without realizing that it's a video call, you're just taking the call. You are attending the call, and on the other side of the window, there is a woman, absolutely without clothes, right? And the screenshot is taken, and that screenshot is used for blackmailing. And a lot of such cases are happening irrespective of the widespread awareness programs which are taken up by the police. Phishing, it's very common, not exactly a sexual offense, but it is quite common. A lot of people have lost a lot of money, and especially children, because these days, parents started giving pocket money to children as young as like 10, 11, 12. And they are also subjected, they are also vulnerable to these kind of scams. Where, somebody, I was just leaving home after lunch for this session. It's quite funny because today I was supposed to talk about cybercrime. When I just started, I was repeatedly getting a call because we were working on multiple issues. Without realizing, I just took the call, and the person said there's a courier that came for you from the bank. I'm going to SMS one number to you. Please call that number and talk to that boy. I said, okay. I mean, I didn't understand. I didn't realize that it's a scam call. And then the person called me like 5 times. Then I had suspicion, and then I sent the number to my, cybercrime team, to Sub-Inspector Harish, and he checked, and then the person was trying to hack into my WhatsApp. And, for 2 minutes I was a little like, imagine if your WhatsApp is hacked. It's very, I mean, you can reverse the whole thing, but it's a hardship that one has to go through. So you have to be very, very careful. We feel that, with smartphone, life has become easy. Actually, it has not. And it's our responsibility to teach the children as well. Cyber defamation. I mean, a boy and girl, they meet, they fall in love, they are in a relationship, they break up, and then the whole dirty linen is washed in the social media platforms. Pictures are being posted, privacy is compromised, and a lot of abusive language being used against the children. Especially from, we have encountered so many such cases in schools in Hyderabad, where the parents come and show us screenshots about this abusive language which is being targeted, against these children. CSAM. I'm going to talk in detail about this after the presentation is over. But ma'am also is taking a lot of, initiative in terms of creating awareness about this issue. As on date in India, child sexual abuse material is one of the most important challenges being faced by us, right? 1, because of lack of awareness among a lot of us. And 2, we don't have the right kind of resources and the adequate manpower to handle this issue. Earlier we used to use this terminology child pornography, but later on there was an amendment done to the act, and now we say child sexual abuse material. So NECMAC, in collaboration with the MCRHRD, is taking up a lot of awareness activities. I foresee the coordination center at the center, Cybercrime Coordination Center. They also run a lot of courses, they run public awareness initiatives online, they try to reach out to different sections of the society, but it's like a small grain in the sand. So there's a lot to be done in this area as well. So what is the MO used by these, cybercrime offenders? Trust building, but just like how it happens in the physical space. A lot of these children don't have the social abilities to form relationships in the physical space. If you look at today's kids, earlier, a kid would have like 5 to 6 friends. And today also they have 5 to 6 friends, but they are not like, meeting in person. It's all online. It's all on chats. It's all like snaps. It's all on like sharing Instagram reels. How does a Gen Z, communicates with other kid? With the peers, they're all sharing reels. And whose reel is it? How exposed they are, how vulnerable they are in this space, they are not aware about all these things. Social engineering is when a potential victim is under the control of the perpetrator, this whole brainwashing that happens. And eventually the victim is subjected to all kinds of, abuse online. And then if the person tries to establish a communication with the victim, then, it leads to a bigger crime. Platform exploitation. I mean, these days, most of the kids are heavily into video games. And most of the video games have this option of in-app or the in-games, chat box. So that is also used sometimes for anonymity. These perpetrators are opting for these, in-game chat box, rather than the regular social media, chats. Grooming, there is a pattern to it. First they establish contact, then they just normalize this communication contact, and then the victim is slowly isolated because the victim is like heavily onto the person who is actually grooming, and she or he stops interacting with the rest of the family members or the friends. Then the actual exploitation happens, and by the time the issue or the crime happens, it's too late. Low self-esteem, we will talk, because of lack of time I'm not going into the PTSD issues of it, but very quickly you can take a look. What is the impact these crimes have on these young, on these young children? There's a psychological trauma, they're socially isolated, and obviously there is a severe decline in their academic performance, and most of them start self-harming. And these days it's really difficult to say anything to the children, right? I mean, 10th class mein marks kam aaye, parents are scolding the kid, and the kid goes and commits suicide, right? it's like it's very fragile. I mean, in fact, our boss ADG Charu ma'am has conducted a lot of training sessions in this regard for the police officers about how to look at this aspect which is actually overlooked in the due course of our work. Then obviously there is long-term consequences. We are talking about a future generation. If this generation is lost, obviously the future is lost. And quickly about the initiatives that we do at Women's Safety Wing. She Cyber Lab, it's a matter of pride for us. Started as a very small group of team. It is handled by Sub-Inspector Harish, very talented young constables such as Arun, and couple of others. And they do an amazing work. It is a preventive initiative that we have started in the Women's Safety Wing. Using the open source investigation tools, these young police officers, they train themselves first, they educate themselves first, and they do something called the cyber patrolling in the suspicious platforms and also in the dark web. So whenever we come across profiles or activities, so especially from repeat offenders, their profiling is done and we generate something called an intelligence report. And then the ADG Women's Safety Wing addresses a letter to the chiefs of the police force in all the states where the presence of the accused is established. And so far we have generated 64 such intelligence reports. This year we have addressed letters to the DGPs of like 14 states, and very recently there was a very interesting case also. I will go into the case studies also. So this is like it's a preventive policing activity that we've been doing. Cyber Congress, this was our very first campaign where we trained all the students about cyber safety, followed by CHANDRA campaign, where the cyber safety campaign focused a lot on girl children. We covered almost 3.75 lakh students since 2021. It was implemented in 3 phases with an amazing support from WCD department and also Department of Education in state of Telangana. Cyber Ambassador program, which is currently ongoing, we wanted to look at the target group studying in government institutions, especially in hostels, the welfare residential schools, and we covered almost 7,350 students and almost 4,000 teachers and 2,000 government schools were covered, and we imparted extremely professionally made content were made available to this target group, and digital safety education was imparted to them. And as you all know, in 2024, Telangana was the first state to have an exclusive bureau for cyber security. And our awareness programs, we continue to do them. Few case studies for you to understand like what kind of cases are reported. WhatsApp calls, 2 minutes on WhatsApp calls scam alert. This was exactly what I just faced in the afternoon. So somebody will call and they will say that I'm going to send you a number. Please call that number, and then a courier is awaiting you or a parcel is awaiting you. So in this, if you look at this number, there is asterisk 401 asterisk, right? This is actually a call forward option given by Airtel, the internet service provider. So somebody calls this victim and they say that we are sending a number, please add this prefix and call that number. The person gets access to the WhatsApp, hacks into it and uses this WhatsApp number to register to commit crime, and also has access into all the private messages of the victim. And the next case is about this is the Telegram big bust that I was talking about. So She Cyber Lab, which is actually doing the cyber patrolling, came across a profile of a suspicious person who was actually handling a huge volume of child sexual abuse material. So we did a lot of investigation, back-end investigation was done. Based on the investigative findings, we generated the intelligence report and it was sent to DGP West Bengal, and there was a very prompt and quick response from West Bengal police, and the person was arrested. When he was arrested, he had just one device, and by then he had almost like 1,000 different child sexual abuse material. How does he get so many pictures of these young boys and girls? It's all from the open social media platforms. So when your kid is posting her picture or his picture, it is just available for everybody to see. Instagram harassment, this is again a very interesting case where a father approached and they said that my girl's Instagram account was hacked and they are just posting very abusive content. So our team started the investigation, and eventually we found out that the whole thing was stage managed by the victim herself, so that she can post the story online and gain more followers. So the children are actually living in this this fake virtual world. They are totally cut off from the realities of the world. So in order to, she even went to the extent of dragging the whole family to the police station, and she started writing graffiti on the walls of the bathroom. She started posting all these abusive content herself, just to create that sensationalism, so that she will have more followers when there is a new account. SMS bombing case, again this is a case where your number must be used by an accused to commit cybercrime elsewhere, and you wouldn't even come to know about it till the time somebody goes and reports. So this was a case where a girl reported about receiving warning messages, and we started investigation. And when we traced the person, this was a Marathi speaking person sitting in Maharashtra, and he had absolutely no idea that his number was being used. His cousin uses his number, hacks into this number, uses this number to register himself on almost 36 social media platforms, and creates a way into WhatsApp, hacks WhatsApp, and starts committing crime. So that is why whenever you use an app, please start using the two-factor verification in your phones. So these are some of the technical, the digital defenses that the children can be taught by the parents. Most important, parental controls. Almost every platform offers this. The network level filters are already inbuilt, and every time a device is given to the child, parent has to ensure that parental controls are activated. Privacy settings, obviously, you should teach children, how to set up the private mode in all these apps. And virtual private networks, VPN is legally allowed in India now, so we can teach children to have VPN enabled devices. Last but not the least, very important, how to report. Most of the time these people go scot-free because we don't report. We feel that acha theek hai, this is something small, why go to the trouble of reporting and doing rounds in the police station. We just simply don't report. Because of that, internet is becoming a breeding ground for all these perpetrators against the children. So these are the different ways we can report the crimes. Thank you so much.
Thank you, Ms. Rima Rajeshwari, for actually educating us on all the words, the terminology, which most of us may have been aware of, but what exactly it is and how it is relevant for our daily lives, we needed to know. And before I hand over the mic to Sri P. Ashok, who will give us a comprehensive overview of the 3 acts, 3 legislations, I just want to add one line that, we tend to see children as victims. But now the time has come, or maybe for some time now, children are also consumers. Children are also consumers of this kind of content on social media, in the dark web. And I remember, when we were children and when our parents gave us some money, whether it was 10 rupees, 20 rupees, our first thing was to go and buy a chocolate or something to eat. And now I read a survey somewhere, maybe last year, that now if a child, and particularly you'll be shocked to know in the rural areas, and in the semi-rural areas, semi-urban areas, if they get 50 rupees or even 30 rupees, they will go to their local pan shop and they will give that money and they will watch pornography for 5 minutes, 10 minutes, depending on how much money they have at their disposal. So can you see, our entire notion of entertainment, our entire notion of pleasure has changed over the years. It's now no longer restricted to a chocolate or something, or a mithai or a samosa, but it's to watch pornography on the web. So children as consumers is something we really need to worry about. And thank you, Ms. Rajeshwari. I mean, we are all so engaged with our WhatsApp accounts, whether calls, whether images, whether videos. So next time you get a call from an unknown number and you get repeated calls or you get a video call, we know what to do. So thank you for that. And over to you, Ms. Sri P. Ashok. Thank you.
ఇది కాదు నో నాట్ దిస్ రిపీట్ ఇది కాదు రిపీట్ చేయాలి నాట్ చేయాలి అక్సెప్ట్ రిపీట్ షేర్ చేస్తాను Honorable Justice Bhattacharya ji, Chair of the today's panel discussion, Bhupati sir, Madam Remaraleshwar garu, Justice of High Court, other dignitaries, all stakeholders assembled today. Actually, I am going to deal on subject of comparison of POCSO, JJ, then BNSS, etc. Before I just wanted to, before I go to my slides, I wanted to emphasize the importance of the POCSO, importance of the JJ, the almost decade plus old act, the crime committed against the children, and the comparison, the study conducted to analyze the crime against the children, it was very, this thing, 30% children below are the, 30% are the children in India, 96% children, the crime committed were the known persons against the children, 96% children are girl child, and 25% are crime committed are the sexual assault cases, 18% are sexual harassment cases, and 56% cases are the age of the accused when compared was age between 21 to 30 years, and in 36% case only the scientific evidence was used. In the morning session, Honorable Justice has been emphasized on the scientific evidence, and also there are 56% cases where the offences committed in the POCSO are penetrative and aggravated penetrative sexual assaults. So other problems, just now Bhupati sir has emphasized on the age determinations. Madam Bhattacharya Madam also brought out latest technologies on the age determination and all. But the issue is when the age, in the age determination, when the people are, children are focused for the radiation, there is also a problem of this thing. So I now focus on the issues which I have given topic. Before commencing, I always quote this statement of our Justice Madan B. Lokur, who is pioneer in the child protection. A child victim is not a statistical number. We are talking of a life that is going to be there for many years. We all, the stakeholders, which we are aware of that. This is because it's a big mandate why we are here. We have the constitutional mandate, we have ratified the UN Convention on the Child Rights, Article 415, 16, 23 and 39 emphasizes on the child protection and child laws. This a small comparison I made between the laws. The definition was given in the definition law. In juvenile justice it is below 18 years under 2, section 2 and 12. Then in POCSO also it is 18 years under section 2D. Child means any person below the age of 18 years. And it's a gender neutral law, you all know. In Bharatiya Nyaya child means any person below the age of 18 years. And key protections provided under the laws. In juvenile justice, the rehabilitation was the important aspects. Care, adoption, trial by the juvenile justice boards, and the importance of the child welfare committees, child welfare police officers, then probation officers, district child protection units, the
special juvenile police units established under Section 107 of the Juvenile Justice Act, the composition of the SJPU, and under POCSO, similar provisions are set up as there. That is, Child Welfare Committee is one of the key areas where the child of the sexual abuse has to produce before the CWC. And SJPU has a pivotal role because under Section 19 it is the duty of the SJPU or the local police to report the offence of the sexual abuse. The District Legal Services Authority is also an important organization because the compensation, distribution and other aspects to be taken care. The shelter is another important aspect where the victims of sexual abuse have to be produced in the shelter homes or the CCI units. Then rehabilitation, many of the sexual abuse victims in our experience, we have seen that many of the children who are sexually abused are losing their education. So such people have to be provided the rehabilitation for their further education, and in some cases children who are working are also losing their jobs. So for such people we have to provide the rehabilitation processes. Then MPTs were one of the important and major challenges in today POCSO cases because we have the time as per the Medical Termination of Pregnancy Act for only 24 weeks. In recent judgment, one of the cases, the Delhi Honorable Supreme Court has remanded back the Honorable High Court of Mumbai, wherein a delay has been caused in conducting medical examination, whereby the parents have changed their version and they wanted to keep the pregnancy without the termination. So another important aspects on POCSO is there in the provisions is that support persons. Thanks to the Women Safety Wing for providing the Bharosa centers where the support services persons have been provided, which was mandated under Rule 4 of the POCSO rules. Then we have interpreter, translators, experts, special educators. All these services need to be utilized either by the police when interacting with the children or the special judge when conducting trial. Then we have offences against children and punishments are also there. So offences under Juvenile Justice Act are punishment for cruelty, unemployment, begging, intoxication, liquor, drugs, vending, peddling, sale of children, corporal punishments like that, kidnapping, etc., which were marked in the Act, we mentioned in the Act from 74 to 89. And in the POCSO Act, before the POCSO Act, we do not have the definitions for sexual assault, sexual harassment, pornography. These sections were brought in as per the POCSO Act. So, and also penetrative sexual assault, aggravated penetrative assaults. All these sections will deal for the victims. Say the punishment is ranging from 3 years to the life, that is remainder of natural life, and also in some cases it is death also. In one of the cases where I was in the field as Additional SP Sangareddy District, we requested to the Honorable High Court for a speedy trial in one of the victims of 6 years old. She was raped and brutally killed. In that case, the Honorable Special Judge of Sangareddy has given judgment within a span of 6 months, and in that case the offender was given punishment of death penalty and also compensation for about 10 lakhs rupees to the next kith of the victim. Though incorporated the POCSO provisions only, Bharatiya Nyaya Sanhita, we have the 63, 65, 64 like that, and in Bharatiya Nyaya Suraksha Sanhita we have to safeguard the procedural, trial and examination of the witnesses. When we are examining the witnesses under 180 BNSS and also under 183 BNSS by honorable magistrates, the care should be taken while interacting with the children. The sensitivity has to be involved when interacting with the children. Trial of the juvenile offenders. In juvenile justice boards to conduct the trial as per section 4 of the juvenile justice board. Child friendly court setup is already there. The preliminary assessment into heinous offences is one of the important area where many of our juvenile justice officers or the police officers, they are not utilizing this opportunity in producing the matter before the JJB to escalate the matter to the children court. Then in POCSO also we have special court orders are there. Special courts are established, special courts are in place, and judgments have been rendered as per timely. The beauty of the POCSO Act, as per my knowledge, is completely it's a procedural law. Completely it is saying you have to do this. Completely saying you have to give this compensation. Completely, directing us, you do this punishment and like that. So in Bharatiya Nyaya Samhita, trial as per the seriousness of the children. Here the heinous offence, that is between 16 and 18 age, this was added in the section 15 was added in our Juvenile Justice Care and Protection Act 2012, owing to the recommendations of the Justice Verma Commission after the incident of that Nirbhaya incident. So guidelines are there under the Bharatiya Nyaya Samhita, Nyaya Suraksha Samhita. The trial, in camera trials, fast tracking of courts, etc. has to be made done. So police involvement is very, very important under all these acts. Especially he is the first responder, and his ability to extract the truth is very important. So we have the setup of juvenile justice, special juvenile police units. Child welfare police officers are also placed in each police station as per GOMS number 25. And special juvenile police units also established in each district, headed by additional deputy commissioner of police to deal with the children of sexual abuse and also the juvenile child in conflict with law. There is, we all know this important aspect of this mandatory reporting provision under Juvenile Justice Act as per section 19, and anybody who come across any incident of such nature of having offence against the child must be reported to the local police, that is special juvenile police units. Otherwise, it's a punishable offence under the same law. And when I am interacting with the CWCs of in a session, one of the CWCs has informed me that despite of several complaints, in one of the districts the case was not registered. Immediately I talked to that concerned officer, then the FIR was registered. Here all the stakeholders is very imperative, especially doctors who doesn't report the matter. In MPT cases, they just do the MPTC and then leave the victim. So this is an offence, and then all the person who got the knowledge will be punished. Then police to follow in the Juvenile POCSO Act, statement recorded to be child sensitive, as I told you, and in the language spoken by the child. Consent and reporting is mandatory reporting is there under POCSO, and protective custody and observations. In all juvenile justice cases, the observation homes, place of safety for juveniles to be provided, and special homes. These homes are run by the government, and in some cases it is by the NGOs. So victim has to be, even the juvenile person in child in conflict with is also to be treated as a most important person. Victims kept safety during trial if needed. During the trial, if the victim of POCSO faces any fear of this thing, then she can be conducted kept in the shelter homes. Then victim compensations has been provided. Justice Madam has been emphasized on this as per our 357 ACRPC with the provisions, and the NALSA fund is there, special, then also SALSA. Then DLSA is responsible for the disbursement of the fund. Compensation fund is available, state victim compensation fund is available, and then BNSS mandates victim-centric trials allow compensation claims. Compensation in one of the judgment, Bijoy versus West Bengal court, the court has also emphasized to give more compensation other than the regular required compensation, since the state has the responsibility to protect the children and failed in its activity. So in-camera trials, most specified, mandatory in-camera trials are there. Mandatory in-camera trials to be conducted, which is already in place. So especially establishment of our court in Hyderabad city is one of the greatest court for the child specific this thing. Then speedy trials, Juvenile Justice Board to conduct a trial in 4 months, but child friendly and fast track courts, as per the POCSO Act, the judgment shall be completed after taking the cognizance in 1 year. So time-bound investigation for the police officer in 60 days, and this is also being seriously monitored by all the child sexual abuse cases and also rape cases by the Government of India Ministry of Home Affairs. So non-disclosure is one of the important provisions available under the Juvenile Justice Act for 74 and also Section 23 of the POCSO Act. Then disclosure also is an offence under BNS 72. Presumption clause is there. This section presumption clause, that is age, has been much talked on this by Sir Bhupati sir. There is abatement clause under POCSO. Whoever abates, then the punishment is there under 17. The presumption is very, very important clause. This the accused has to prove his guilt. Then public awareness is one of the important arena in which all stakeholders have the responsibility to conduct public awareness about the POCSO Act and JJ Act and the offences committed. In this aspect, the Bharosa centers are doing a lot of work by analyzing the hotspot analysis and then conducting awareness campaigns. This is some just words that we have to conduct copies to the victims. No face-to-face meeting of the child accused, and no to keep the children in the police station beyond sunrise and sunset. No publishing of material. Safe corners. In recent times, we have opened many safe corners in the police stations for dealing with the POCSO as well as the juvenile cases. There is beautiful institutional mechanism as established to provisions have been provided in Telangana. One is that Bharosa, you all know that Bharosa officers are also is there. A single window system, support for handling towards quest for justice delivery and rehabilitation. It's a 24 hours running organization, and video conferencing facility is also there. In some of the cases, honorable magistrates have conducted video conferences. Recording 161 statements by the police officer. In all Bharosa Center, one sub-inspector of police has been provided. One of its kind child-friendly court was established in Hyderabad city. It's a paperless center administered by the Bharosa Society, headed by the Women Safety Wing Additional DGP Madam. And child rape and child sexual abuse cases have been taken. Initially, it was opened in 2006 with one center, but in 2021, it was started in a massive way. By now, we have created about 29 centers across the Telangana state, each district having one Bharosa center, and in tri-commissioners we are going to have 2-3 centers in each district. Thereby we are going up to 35 centers. Immediately, as soon as the victim comes to the police station, she will be immediately sent with a requisition to the Bharosa Society, where the Bharosa people will go, and then victim will be examined by the psychological person, who is psychologist already recruited there, and she will examine the victim, and thereafter, after talking to her, after conducting an interview, then she will put to before the police officer for recording the statement under 24 of the POCSO Act. And then medical examination also conducted in Hyderabad city. We have the facility. In some other district center we do not have, and that if that facility has been provided, the long waiting of the victim at the hospital will be avoided. Then we have the legal facilities. The legal support person is provided for handling the victim and their legal rights, and also accompanying the victim for recording 164 statement at the court, magistrate court. Rehabilitation rehabilitation has been provided. Shelter is being provided by producing before the CWC. We will outreach to generate awareness. And the beauty of the Bharosa Society and Bharosa Center is we have provided the victim compensation fund about ₹1 lakh in each Bharosa Center to meet the immediate medical expenses of the victims of the sexual abuse. And this is a feather in our cap that the Honorable Supreme Court in Nipul Saxena versus Union of India has categorically stated to provide one-stop centers, and one such center which is already been set up is Hyderabad Bharosa. This can be used as a model for another one-stop centers in the country. So we have also provided the institutional mechanism provisions. Is child-friendly corners have been created. 10 centers have been created in Sangareddy, and already in operational. With the help of UNICEF, we have taken the assistance from the UNICEF also in providing these centers, where the victims of juvenile children or child in conflict with will be provided, and also we are using these centers for the victims of sexual abuse. Infrastructure in place. These are the places we have already created. This is a reserve open. This is the creation of our juvenile justice, special juvenile police units. Pre-protection rules also we are following for the children under Rule 16 of the JJ Act. No FIR shall be registered like that. And forwarded the nature, the probation officer facilities are being used in the cases. And these are all the prohibited. Production of the child is to be in conflict with the law before the board. No handcuff for the children and not used or coercive forces. Inform the charge made against the children to the parents and guardians. Not to compel the child to confess his guilt. Like parents, guardian may be present during the interview of the children. No feeling of custodial interrogation. Not to ask the child to sign. CWP shall be in plain clothes, which we are ensuring. And general principles is one of the important area we are focusing. The diversional alternative principle we are implementing in Hyderabad through she teams, where the victims of children in conflict with the law who are caught by the she teams are being diverted at the police station itself by taking an undertaking from them and conducting counseling. Then principal assessment is one of the important area where principal magistrate will conduct the Juvenile Justice Board for the conducting trial of the accused of 16 and 18 years age. This is wage verification, sir, as Ali categorically treated. Sir, here we are facing and we need your intervention here. The most of the police cases, when we see the FIRs, only the bona fide certificate are being submitted with the charge sheet. Bona fide certificate is not a valid certificate. So I think we need some good insight on this, because many of the problem we are being facing on ground is that many of the victims are illiterate. They do not have the birth certificates.
Sir, for that also there is an answer by Supreme Court.
Yes.
TC is also not accepted.
That TC is also not accepted. Study certificate is also not accepted. Only the matriculation certificate accepted. Board certificate.
Only those mentioned.
Matriculation and board certificates, sir, and also municipality and corporation and panchayats. The problem we are being facing is that the children are illiterate. They do not have the date of birth. Only we have the evidence is that Aadhaar card, which is not admissible. And the last availability is that bone ossification test. In many of the cases, it is going in favor of the accused, because the doctor is giving the his opinion between 17 to 18 years, and sometimes are 16 to 18 years, and in sometimes it is 16 to like that. So that is also the problem. And also here in bone ossification test, since we have to expose the children for the radiation, this thing, that is also posing danger to their
so also driving license.
Yes.
And Aadhaar card also not accepted.
Not accepted. Yes, that's what, sir. So this is actually for the consumption of our police officer. I have specifically made this slide. Then in this recent Honorable Supreme Court judgment again reiterated that in the form of school register was not sufficient to arrive at the conclusion that the POCSO were less than 16 years. So invariably we need to have a date of birth certificate and SSC certificates. Otherwise, we have the only method is bone ossification test. So in this thing also, we have a lot of stakeholders are important in this convergence for converging all the laws. So these are the police are to record the statements under 24 of the POCSO Act in plain clothes, the police officer, and language to be used, the same language spoken by the children, the medical examination to be conducted, the frequent breaks to be given to the child. So police officers should read out loudly to the victim and then record. The child dignity have to be protected like that. And then magistrate has to record the statement within 24 hours as emphasized in the Tarkar Shivana versus Karnataka state, which is not happening, sir. The statement have to be, this is one of important ideas which I wanted to emphasize. Then medical examination is another problem. This is also not happening in 24 hours. The victims are being in queue. So the medical, it's a actual law. It is called as a medico-legal emergency as per the POCSO 27 Act and also in the 164 of 184 of BNSS. So compensation. These now we have trained all the SHOs in the states, sir, through our Honorable DGP, sir. We have providing now the Form A format under POCSO rules to the victims, giving entitlement of this thing, and also preliminary assessment to report. So this is the Child Welfare Committee. In three circumstances, we are producing the victim before the Child Welfare Committee, when the accused and victim are in the same household, because we have the most of the cases pertinent to this case, also 94% cases are on this nature. Child is living in child care institution, and when the child is without any care. So support services we are providing, appointment of support person is there. Then child-friendly procedures of all judges, they know this. This is an important aspect, sir. We all converged today to make the child an important aspect, make the child to be free, and make the child to not to re-traumatize, all the stakeholders to converge, and there are important judgments which are there. And finally, I request, let us protect the child rights and the best interest of the child. Thank you so much, one and all.
Thank you, sir.
Thank you very much, Sri Ashok. And I will not say anything because we are already 25 minutes behind our schedule. And just 1 minute. And we have another session. Justice Vijay Sen is waiting for his session. So I will not take my 10 minutes. Just wanted to thank my panelists for raising very important issues. To Mr. Bhupati for showing us the decisions, citations, to Ms. Rajeshwari, educating us about so many different concepts, cyber crimes, child sexual abuse material. Interesting that from child pornography now we use that expression, child sexual abuse material, and because it shows that there's a shift somewhere in our thinking, that pornography, child pornography is not for our entertainment, but if we actually indulge in it, then we are liable for an offense. And to Sri Ashok for giving us a total overview of what the laws are and where to go in case you have a problem. So thank you very much, and but most of all to all of you, all my colleagues, my esteemed colleagues, my friends, Ms. Ramachandran, everyone, Mr. George, everyone in the audience I know. Thank you very much for being with us, and all the best for the next session. I'm sure that will be an equally great success. Thank you.
Thank you, Milad, and other honorable resource persons on the dais for such inspiring and thought-provoking deliberations by focusing on important provisions relating to child in POCSO Act cases, along with other laws. We would like to take this opportunity to express our gratitude to Her Lordship and other honored resource persons for their generosity and kindness in gracing this occasion by felicitating them. For this,
sir, just 1 minute, sir. Just 1 minute. With the kind permission, Chair, I want to tell one important judgment, because what is happening is the Supreme Court frowned the practice of using the word child pornography in judgments, but still judges are using the word child pornography. Recent judgment, that we should keep it in mind. They frowned it. Recent judgment, Just Rights for Children, Aliens and Others versus S. Harish and others, 2024 SEC Online, Supreme Court page 2611 is its citation. Please note down. Supreme Court frowned it. They asked the courts to use the word CSEAM, C-S-E-A-M, CSEAM, child sexual exploitation and abuse of material. They gave such direction to the Union government also. Press is correctly using. Recently I read some articles in Hindu and Times of India. They used the word CSEAM. They did not use the word child pornography. But we are using. Please see judgment, paragraph 260, Roman 1, Roman 2. Please kindly see. Paragraph 260, Roman 1, Roman 2. There is a wonderful judgment of Justice J.B. Pardiwala and Justice Chief Justice D.Y. Chandrachud. Wonderful judgment. They frown the practice. The government may not follow, but we have to follow. Please kindly note this.
Thank you, sir.
Thank you.
Sir, now I humbly request Honorable Srimati Justice E. Tirumala Devi, Madam, Judge High Court for the State of Telangana, to kindly present a memento to Her Lordship, Honorable Ms. Justice Maushami Bhattacharya, Judge High Court for the State of Telangana, and Chairperson of the Committee to monitor the cases filed under POCSO Act.
Now I humbly request Honorable Sri M.V. Ramesh Sir, Principal District and Session Judge, Asifabad, to kindly present a memento to Honorable Sri C.H.K. Bhupati, Principal District and Session Judge, retired. Thank you, sir. Now I humbly request Dr. Chetana, IPS, Women Safety Wing, to kindly present a memento to Ms. Rema Rajeshwari, IPS, Deputy Inspector General of Police, Women Safety Wing, Telangana. Now I humbly request Sri Akeshwar Rao, Joint Director, Women Development and Child Welfare, to kindly present a memento to Sri Pagadal Ashok, Additional Deputy Commissioner of Police, North Zone, Hyderabad. Now I seek the permission of the Honorable Chair to declare the session closed. Now it is time for tea break, and all are requested to reassemble for the next session at within 10 minutes. In the lawn, tea is available, sir, for participants.